Ladies and gentlemen of the jury, we are about to commence a criminal case. New York County has filed a complaint which alleges substantially that on May 30th, 2007, within New York, the defendant, Samuel Williams, engaged in the crime of armed robbery of Heather Potter. The defendant, Samuel Williams, has pled not guilty. The state of New York, therefore, has the burden of proving the defendant's guilt beyond all reasonable doubts. The state of New York, representing Heather Potter, is represented in this case by Ms. Robbins. The defendant, Samuel Williams, is represented in these proceedings by Mr. Dodd. Now, ladies and gentlemen, there are some general instructions of law that apply to all criminal cases. I want you to bear these principles in mind. The complaint, which I've read from, is itself not evidence. It creates no inference of guilt. Therefore, no member of the jury should in any way permit herself or himself to be prejudiced against the defendant just because a complaint has been filed against him, or because he was arrested, or because he has been placed on trial. Under the Constitution, every defendant is presumed innocent of the charges made against him. Before you can find him guilty, the state must prove his guilt. The defendant does not have to prove his innocence. The presumption of innocence remains with the defendant unless or until a jury decides that he has been proven guilty beyond a reasonable doubt by evidence admitted at the trial. In the course of the trial, you will hear evidence from a number of witnesses. You're going to have to make judgments about their credibility. You're going to have to decide which testimony you should believe. Listen carefully to the testimony of all the witnesses. Keep it all in your mind until you hear the whole case. As you listen to each witness, you should consider his or her interest or lack of interest in the outcome of the case. You should rely on your own experience, judgment, and your own common sense in evaluating whether a particular witness is the kind of person that you would be inclined to believe in matters of the highest concern. You should keep an open mind about all of this evidence you will be hearing until the very end of the trial. During the trial, an objection may be made to some evidence, and I might direct that a question not be asked or not be answered. You should not speculate about what evidence would have been had I allowed it, or why I did not allow it. If I should ask you to disregard some statement made by a witness during trial, you must disregard it. There are some things you should not do during the course of the trial. You should not go out and do any investigating on your own or make any inquiries. Above all, you must not talk to anyone who is involved in this trial, these lawyers, the witnesses, the defendant, or members of his family. You also should not discuss the case among yourselves during the course of the trial. You will have as much time as you need after the trial is over, when you will go into the jury room and deliberate thoroughly and adequately. But that, of course, is at the end of the trial, not during the trial. Ms. Robbins, you may now address the jury.
Ladies and gentlemen of the jury, my name is Ms. Robbins. I am representing the state of New York. You're about to hear the opening statement. This is your opportunity to hear what the state of New York expects the evidence in this case to show. I want to make one thing perfectly clear before I go any farther. What I say and what the defense lawyer will say during the trial, during the opening statements, and during the closing arguments are not evidence in this case. The evidence is what you will hear from the witness stand, from the witnesses under oath. You people, as a jury, are representatives of the people of the state of New York and of New York County. In that capacity, your very important duty is to follow the law that the judge will give you, to analyze the evidence, and to apply that law to the evidence and to the facts of this case. I would only ask you that you use your sound judgment and common sense in carrying out that duty. The state has charged the defendant with the armed robbery of Heather Potter. To prove its case, the state will present witnesses for your consideration, including Heather Potter herself, who will describe to you the event that took place on May 30th, 2007. You will also hear the testimony of the arresting officer, Police Officer Mark Riley. This is the basic evidence that I anticipate presenting on behalf of the state of New York. I would ask you to watch and listen to these witnesses who testify very closely for any motive or reason that they may have to tell you anything less than the truth. Remember, it is your job to draw conclusions from this evidence. I am confident that the evidence will convince you beyond a reasonable doubt that the defendant is guilty of the crime of which he is charged. And at the end of the trial, I'm going to ask you to stand up here and ask you to find him guilty of armed robbery. Thank you very much.
Thank you, Ms. Robbins. Mr. Dodd, would you like to make your opening statement now?
Yes, thank you, Your Honor. Mistaken identity. Let me say that again. Mistaken identity. Hello, ladies and gentlemen. My name is Mr. Dodd, and I represent Mr. Williams in this case. The purpose of a trial is for both sides of a case to have an opportunity to present evidence. You have heard the prosecutor give her opening statement on the evidence that she intends to present to you. The defendant, by this opening statement, also has an opportunity to outline for you the evidence that we intend to present. The defense will present an alibi for the defendant, his neighbor, Mr. Donald Pinzan, who will account for his whereabouts on the evening of May 30th, 2007. You will also hear testimony from an eyewitness memory expert who will discuss factors that often lead to mistaken eyewitness identifications. The prosecution's case relies on Heather Potter's identification, but we will show you that this is a case of mistaken identity. We agree that this was a heinous crime and someone should be punished, but that someone is not Mr. Williams. Keep in mind that throughout this trial, the state bears the burden of proof. They must prove beyond and to the exclusion of any reasonable doubt that Mr. Williams committed this crime. At the conclusion of this case, I will have another opportunity to address you. At that time, I will be able to give you the final argument. It is in that final argument that I will ask you to find my client, Samuel Williams, not guilty of armed robbery. Thank you very much.
Thank you, Mr. Dodd. Ms. Robbins, would you like to call your first witness?
Yes, Your Honor. The state would like to call Heather Potter to the stand. Please state your full name.
My name is Heather Marie Potter.
Heather, where are you employed?
The Embassy Suites in New York City.
And how long have you worked there?
5 years.
Could you describe your responsibilities at the Embassy Suites?
I am responsible for staffing the front desk and confirming reservations and checking in guests.
Ms. Potter, describe the lobby of the Embassy Suites Hotel.
It's an old-fashioned hotel. There's plate glass windows in the front and shelves on both side walls and couches on the floor. The front desk is in the middle, facing forward. The whole lobby is 50 feet wide and 65 feet deep.
Have you ever been robbed before?
No.
I'd like to now discuss the particular robbery in question. Do you recall what day of the week it was and what time the incident took place?
It was Friday at 9 p.m.
On Friday, May 30th at 9 o'clock p.m. Where were you?
I was standing in the lobby behind the front desk.
Tell us what happened.
There was no one in the lobby or at the front desk except myself. The door to the hotel opened and someone came in. I was on the phone booking a reservation for a future guest, so I didn't look up. People tend to ask me questions if I make eye contact. So I waited until the conversation was over. When I hung up the phone, the person was gone. I assumed it was a guest on the way to their room, so I didn't think much about it.
So you saw him enter the lobby?
Yes.
And you were looking at him?
Well, I just glanced at him. I knew it was a man, but I didn't notice anything else at that point.
Would you say that during that time you got a good look at him?
No.
All right. Then what happened next?
Well, the phone rang again, so I answered it. And right after I hung up the phone, I felt a gun pointed at the back of my head. And a man said, "Give me all the money."
Can you describe the gun?
I didn't really see it. Like I said, the gun was pointed at the back of my head.
And then what happened?
I emptied my drawer of all the cash and handed it over to him.
Could you see what the man was wearing?
Yes, he was wearing a baseball hat and jeans and a jacket.
How long would you say it took the whole thing to go down?
No more than 2 minutes.
And then what happened?
There's a swinging gated door behind the front counter that opens out onto the lobby, but it's always locked. He fumbled with the lock for a minute and then ran out into the lobby and out of the hotel. That's when I got a good look at him, when he was trying to make his escape.
Ms. Potter, do you remember talking to the police at the hotel?
I remember they talked to me, but I don't remember what I told them. I was just so upset I couldn't think straight.
Can you now describe the man who robbed you on May 30th?
Yes, he was a white male in his 20s, average build. I didn't notice anything unusual or distinctive about him.
Ms. Potter, do you see the man in court today?
Yes, I do. He's right there, at the defense table.
Ms. Potter, that evening, did the police contact you again?
Yes.
What did the police contact you about?
They wanted me to come down to the station to look at some photos. I said yes, and I went to the station.
What happened there?
I came to the station, and there was a small waiting room that I was in for a while, and Detective Riley then took me back to a small room, and I looked at 6 photos. I immediately recognized him as the man who robbed me.
Did you tell Detective Riley that?
Yes.
Tell us about these photos Detective Riley showed you.
They took me back to the lineup room, and Detective Riley showed me some photos. I looked at them for a short while and told Detective Riley that the photo on the top left was the man who robbed me at gunpoint at the hotel.
How many photos did you look at?
6.
What feature was it that led you to believe it was Mr. Williams?
No particular feature, just his general appearance.
Are you sure it was the defendant, Mr. Williams, who robbed you at gunpoint on the evening of May 30th?
Yes.
I have no further questions for this witness, Your Honor.
Mr. Dodd, would you like to question the witness?
Yes, thank you, Your Honor. Good afternoon, Heather. I'm Mr. Dodd, the defense attorney in this case. I would like to ask you some questions regarding the robbery at the hotel in which you work. Are you currently working in the same Embassy Suites that was robbed?
Yes.
Heather, you were an eyewitness to the robbery that occurred at the Embassy Suites Hotel, is that correct?
Yes.
Do you have any vision problems?
No, I don't.
And do you wear contacts or glasses?
No, I don't.
When was the last time you had your eyes checked?
About 2 months ago, I got something in my eye and they checked it out, but my vision is fine.
How about your memory, your ability to recall?
No problems.
Was the perpetrator wearing any jewelry? For example, a watch?
No, not that I recall.
You said the perpetrator was wearing a baseball cap.
Yes.
Could you see any part of his head?
No, the hat was covering the top of his head.
After the perpetrator came behind the counter, did he say anything?
Yes, he said, "Give me all the money."
What did you do next?
Well, I opened my drawer, I gave him all the hundreds, 50s, 20s, and 10s.
Could you see him at this point?
No.
So you had the best view of him when he was exiting the hotel. How close were you to him?
About 5 feet.
Did you notice any distinguishing features on his face, like birthmarks, or scars, or moles?
No.
What was his facial hair like?
He was clean shaven.
And what was he wearing?
He was wearing a baseball hat, and he had on jeans and a jacket.
What color was the jacket?
It was a dark colored jacket.
Did he verbally threaten you at any point?
No.
Did the police have you make an identification at the police station?
Yes.
Would you say you got a good look at the perpetrator?
Yes.
What are the color of his eyes?
I don't know.
What type of jacket did he have on?
It was a dark jacket.
What color was the baseball hat?
It was black.
Did it have anything on it?
There was something embroidered on the front
When did you notice that something was embroidered on the front?
when he was making his escape.
What was the embroidery?
I don't remember.
When the police brought you to identify Mr. Williams, did he look exactly like the person who brought you?
Well, not exactly. I mean, he wasn't wearing his hat and he was wearing different clothes.
Now, Heather, you're making a lot of assumptions, aren't you?
In regards to what?
That he was not wearing his hat. You don't know if Mr. Williams owns a baseball hat.
I know he had one on when he came in to rob me.
It might be that you are assuming that Mr. Williams robbed you and it wasn't Mr. Williams.
No, I recognized him from the lineup.
You are convinced that this was Mr. Williams, aren't you?
Yes, I am.
And nothing is going to change your mind?
No, I'm confident that the defendant is the man who robbed me.
And you've never made a mistake about identifying a person before?
Not to my knowledge.
Never seen two people who look alike?
Well, of course, a lot of people look alike.
Ever mistaken one person for another?
Well, yes. Hasn't everyone?
Thank you, Your Honor. I have no further questions.
Ms. Potter, you may step down. Ms. Robbins, you may call your next witness.
The state calls Detective Mark Riley to the stand. Detective Riley, when did you first get involved in this case?
I was in my car and received a radio call directing me to the Embassy Suites Hotel.
And when was that?
It was 9:05 p.m., May 30th, 2007.
What happened when you got there?
There was a woman standing behind the front desk sobbing.
Did you talk to her about the incident?
Yes, Miss Potter was pretty shaken up, but she told me what happened.
Did Miss Potter describe the man?
Only generally. She said he was a young white male in his 20s with an average build, dressed in jeans, wearing a dark jacket, and a baseball hat. She said she didn't notice anything unusual about him. She couldn't tell me his height or his weight, but she was very upset.
Did she say anything else?
Nothing except the details of the crime.
And what happened next?
I called the description in headquarters and they sent it out over the police radio.
And what happened next?
I drove back to the police station.
Did anything happen on the way back to the police station?
Yes.
Could you describe what happened?
Yes, I saw a man who fit the description given by the eyewitness.
Did you pull him over?
Yeah, I pulled him over to question him and he ran.
And then what happened?
I chased after him, caught him, placed him under arrest, and drove to the station.
And what was this person's name?
Samuel Williams.
After you returned to the station, what happened?
I called Miss Potter and asked her to come down to the station to view a photo lineup.
Did she come?
Yes.
Tell us how the lineup was constructed.
I took a photo of Mr. Williams standing in front of the white background we have in the booking room. Then I matched his photo up with 5 other photos from our male adult offender file.
How did you match up his photo with the other 5 photos?
I matched the other 5 photographs based on the description the eyewitness provided.
Did you give the eyewitness, Miss Potter, any instructions before viewing the photo lineup?
Yes.
Could you describe them?
Yeah, I said the person may or may not be in the lineup and to take her time. Then I placed the 6 photos down on the table and waited for her response.
And what was her response?
After a short while, Miss Potter pointed to Mr. Williams' photo and stated that he was the person who had robbed the hotel and pointed a gun at her.
How long would you say it took between the time of the robbery and the identification of Mr. Williams in the photo lineup?
5 hours.
Thank you, Your Honor. I have no further questions for this witness.
Mr. Dodd, you may now cross-examine.
Thank you, Your Honor. Is it normal procedure to have a lineup the same day as the crime occurred?
Well, it depends on the case, the evidence, and whether or not we're able to apprehend the perpetrator.
When Ms. Potter made the identification, how certain was she?
She appeared to be very sure of her decision.
Did you get a confidence rating from her on a scale of, let's say, 1 to 10?
No.
Well, then how can you be sure she was very confident?
She just appeared to be very confident.
Have any of your eyewitnesses made mistakes in the past in misidentifying the suspect?
Not to my knowledge.
So it may have happened, but you're unaware of it.
Yes, I guess that's possible.
I have no further questions, Your Honor.
The prosecution rests, Your Honor.
Mr. Dodd, you may now call your first witness.
Thank you, Your Honor. The defense calls Dr. Roberta Ingalls. Dr. Ingalls, what is your educational background?
I'm a 1988 graduate of the University of Virginia, where I received my bachelor's degree in psychology. In 1994, I earned my PhD from the University of North Carolina at Chapel Hill, where I specialized in cognitive psychology. I've been a professor of psychology at New York University since 1994. I'm a member of the American Psychological Association and the American Psychological Law Society.
Can you briefly familiarize the court with your work history and research interests?
Yes. As I said, I have been at New York University since 1994, teaching and conducting research. At NYU, I teach both undergraduate and graduate classes. At the undergraduate level, I teach a course entitled Cognitive Psychology. At the graduate level, I teach a course on the psychology of human memory, which includes a great deal of lecture on eyewitness memory. In terms of research, I have published approximately 40 scientific papers in scholarly journals and chapters over the course of my career in academia. I have had continual funding from the National Science Foundation. I am also in process of working on a book covering issues in cognitive psychology.
You indicated, Dr. Ingalls, that you are a cognitive psychologist. Could you describe for the court what a cognitive psychologist is and what being one entails?
Certainly. Cognitive psychology is one of the many divisions in American psychology. Cognitive psychologists focus on human perception and memory. Cognitive psychologists who work in psychology and law focus on topics such as eyewitness identification, repressed memories, and the detection of deception.
As a cognitive psychologist, what is your main area of expertise?
My main area of expertise is eyewitness memory.
Dr. Ingalls, tell us about how eyewitness memory works.
Human memory is a complex cognitive process involving 3 distinct stages. At the first stage, information is perceived and encoded into memory. At the second stage, encoded information is stored in memory. At the third stage, stored information is retrieved from memory, such as when an eyewitness is asked to recall information about a crime or to identify a perpetrator from a photo array. Memory is vulnerable at each of these stages. Certain factors can influence the way a memory is remembered.
Your Honor, I request permission to tender this witness as an expert.
This witness has been so qualified. Please proceed.
Thank you, Your Honor. As a result of the factors that influence eyewitness memory, do mistaken identifications occur?
Yes, mistaken identifications occur with some frequency. There have now been hundreds of people who were convicted of crimes, spent time in jail, and then were later found to be innocent based on DNA testing. In these cases, mistaken eyewitness identification is the single most common factor leading to erroneous conviction.
You say you research factors affecting eyewitness identification. Would you consider yourself to be an expert on issues that affect the accuracy of eyewitness identification?
Yes, I would. I have conducted scientific studies on the accuracy of eyewitness memory and the conditions under which errors occur. I have made original contributions to scientific journals in the field. I have published 15 papers on factors affecting the accuracy of eyewitness memory, and I have attended and presented empirical work at conferences focusing on the topic of eyewitness memory.
Given your expertise, have you ever been involved in litigation such as this involving eyewitness identification?
I have been involved in 6 cases.
Have people solicited your involvement but you declined?
Yes.
Have psychologists identified any factors that diminish the accuracy of eyewitness memory that may affect identifications?
Researchers have identified several factors that diminish the accuracy of eyewitnesses. For example, high stress. Wrong identifications may occur in the absence of high stress. However, studies have demonstrated a statistically significant correlation between high stress and less accurate eyewitness identifications.
Would you elaborate on high stress as a factor said to increase the likelihood of mistaken eyewitness identifications?
Certainly. The Yerkes-Dodson law proposes that the relationship between arousal and performance can be plotted as an inverted U, where with moderate increases in arousal, performance is improved, but with too much arousal, performance declines. In terms of eyewitness identifications, the best possible scenario is when the eyewitness is alert, meaning a little bit aroused, but not so aroused that the eyewitness's attention is too focused and narrow to make a positive identification.
Dr. Ingalls, have you personally conducted any research investigating the accuracy of eyewitness memory for persons encountering exposure to highly intense stress?
Yes. In fact, I have conducted some relevant research. Most studies that examine the accuracy of eyewitness identification are conducted in settings that do not stimulate the participant in the same way as an actual life-threatening event would. I was interested in overcoming this limitation, so I conducted a study using the U.S. Army Survival School training program for the study of realistic threat-to-life stress in humans. This setting allowed me to apply severe stress in a uniform manner, controlling for factors that other settings could not.
Could you please describe your study?
Certainly. 334 recruited active duty military personnel enrolled in military survival school training were the subjects of my investigation. The personnel had been in active duty for an average of 4 years, and the average age was 25. Participants were told that their participation in our study would not affect their outcome in survival school. All agreed to participate. The military personnel were placed in the wilderness where they were captured and put in mock captivity in a prisoner of war camp. The participants were then interrogated in a high-stress manner by an interrogator 12 hours after being put in the prisoner of war camp. The interrogations were characterized by participants receiving threats of physical violence against them if they did not obey.
So after the participants were interrogated, what happened?
24 hours after being released from the prisoner of war camp, subjects returned to the survival school training facility and were told that they would need to identify the person interrogating them during their capture. 16 photos were shown in a sequential manner, or one at a time. After each individual photo, participants were asked to write down yes or no on a piece of paper as to whether or not this was the person who interrogated them. They were not allowed to go back and review any pictures. Also, we asked them to rate their confidence from 1 to 10 that this was the interrogator. After analysis, I found that only 49% of the participants were able to correctly identify their interrogator.
Dr. Ingalls, are you able to use this particular study to determine whether the research indicates that stress is likely to influence the accuracy of eyewitness identifications?
Yes, I am.
High stress is something you would predict to increase the probability of wrongful eyewitness identification?
Yes.
And in that regard, did you have an opportunity to review the deposition testimony and other documents related to this case?
Yes, I have.
In addition to those materials, is it fair to say that you have reviewed other depositions, affidavits, and items of discovery that have been exchanged between the two parties in this case?
Yes, I believe so.
Now, based on what you reviewed, do you have an opinion of whether or not the research indicates that high stress was likely present when Heather Potter identified Samuel Williams?
Yes, I do.
What is that opinion?
My opinion is that the presence of the gun and the way in which Ms. Potter was confronted would simulate a high-stress environment, which would decrease her ability to make a correct identification. This study provides me with a basis for concluding that a correct identification is unlikely given the circumstances.
In your review of the documents and materials, did you find that Ms. Potter, the eyewitness, was under high stress?
Yes, I believe high stress was present. The police officer's report of her demeanor when she arrived provided me with evidence that Ms. Potter was under a high degree of stress.
No further questions, Your Honor.
Ms. Robbins, you may cross-examine the expert now.
Good afternoon, Dr. Ingalls. I'd like to ask you a few questions about your research and your testimony here today. You stated earlier that you had testified in 6 cases before. Have you ever testified for the prosecution before?
I have never been asked.
Have you ever been retained by this lawyer before?
No.
It is my understanding that a number of psychologists make a business out of testifying on issues such as these in court. Would you agree?
I do not personally know any psychologists who do this, so I cannot say.
But have you ever heard of this before?
I have heard people claim that before, but I've never met a psychologist who makes their living by testifying in court.
Who are you getting paid by?
I have been hired by the court as a court-appointed expert.
How much are you getting paid per hour?
I charge $150 per hour.
So how much have you made on this case so far?
Well, including preparation, travel, and being here today, I will have made $3,500.
Have you ever lied before?
Never under oath.
I have no further questions for this witness, Your Honor.
Dr. Ingalls, you are now excused. Mr. Dodd, you may call your next witness.
Thank you, Your Honor. The defense calls Mr. Donald Pinzan to the stand. Mr. Pinzan, how do you know the defendant, Mr. Williams?
He's my tenant, and he lives next door to me. We're not really friends, but I know who he is.
Mr. Penzan, would you tell us what you were doing between the hours of, say, 8 p.m. and 10 p.m. on the night of May 38, 2007?
Well, like I told the police, I was home that night. There was a ball game on. The Mets were playing the Braves. I'm a big Mets fan myself, so I was at home watching the game.
What, if anything, can you tell us about the whereabouts of Samuel Williams during those times?
Well, I saw him in the hallway around 7 o'clock. He was unlocking the door to his apartment, and I was taking my garbage downstairs. I returned from the basement a few minutes later and heard his TV on. I know because the walls in that place are so paper thin you can hear just about everything. Anyway, I went to bed around 11:15. He still had his TV on. I had some trouble, but eventually I managed to ignore the noise and fall asleep.
When you saw him earlier that evening unlocking his door, what was his demeanor like?
I didn't notice anything. I just looked like he was trying to get into his apartment.
Do you know if Mr. Williams has a job?
I would imagine so, but we've never had a conversation about work before.
Has Mr. Williams ever been late paying rent? Are you aware of any money problems?
He's been a few days late before, but nothing problematic.
Is Mr. Williams a good renter?
Well, he keeps his TV on a little too loud, but he's respectful, so yes.
Thank you. No further questions.
And now cross-examine.
Thank you, Judge. Mr. Penzan, you stated that the last time you actually saw Samuel Williams, the defendant, on the night of the armed robbery was at 7 o'clock p.m. Is that correct?
Yes.
The crime took place somewhere around 9 o'clock p.m., which would give Mr. Williams 2 hours to get to the crime scene. Have you ever accidentally left something on in the apartment, like a television, while you ran out to run an errand or something?
Plenty of times.
And you merely heard his television that night. You didn't actually see him. Is that correct?
Yeah.
Thank you, Your Honor. I have no further questions.
Mr. Ponson, you may now step down from the witness stand.
The defense has no further witnesses.
Is the prosecution prepared to give its closing remarks?
Yes, thank you, Your Honor. Ladies and gentlemen of the jury, when I first stood before you at the beginning of this trial, I told you what we, the state, would prove. I told you that we had an eyewitness who would testify to what she saw happen that Friday at the Embassy Suites. You even heard Miss Potter get up on the stand and testify that she saw Mr. Williams and got a good look at him. She told you about how she identified Mr. Williams from a lineup array. You heard Detective Riley testify to the arrest of Mr. Williams and the procedures used during Miss Potter's identification. Now you have heard the defense say that Miss Potter was mistaken. An eyewitness expert even tried to pass the identification off as a possible mistake. Ladies and gentlemen, Miss Potter is not mistaken. She took a good, long look at the defendant and then picked him out of a lineup. I want you to think to yourself, what, if anything, does Miss Potter gain from testifying here today? I'm very confident that when you review the evidence and weigh the facts in this case, your decision will be a very easy one. And that decision is a guilty verdict of armed robbery.
Is the defense prepared to give its closing remarks?
Mistaken identity. Ladies and gentlemen, at the beginning of this trial, you heard the phrase mistaken identity. After listening to the witnesses and looking at the evidence, it's time for you to make a decision. However, before you decide the outcome of this case, I want to remind you of your civil duty to the criminal justice system. Let me point out some highlights of the evidence exposed to you during the trial. I want you to remember and consider the testimony of Dr. Ingalls, an expert psychologist who described for you the relationship between stress and eyewitness identification accuracy. You heard her describe the results of a study that she conducted. The results from her study clearly show stress reduces people's ability to accurately identify someone. Thus, the stress that Ms. Potter experienced was likely to cause mistaken identification. You heard Mr. Penzan testify that he saw Mr. Williams enter his apartment and heard his TV on that evening. I want you to remember what Ms. Potter stated on the stand. I want you also to remember that the state must prove beyond and to the exclusion of any reasonable doubt that Mr. Williams committed this crime. Ladies and gentlemen, this is an extremely high burden to meet. I'm confident that you will return the only verdict that speaks the truth, a verdict of not guilty. Thank you.
You have had an opportunity to hear all of the witnesses. It is now your duty to find the facts from all the evidence admitted in the case. To those facts, you must apply the law as I give it to you. The determination of the law is my duty as a presiding judge in this court. It is your duty to apply the law exactly as I give it to you, whether you agree with it or not. You must not be influenced by any personal likes or dislikes, prejudice, or sympathy. That means you must decide this case solely on the evidence before you and according to the law. As you know, the defendant has pleaded not guilty to the crime charged in the indictment. The indictment is not any evidence at all of guilty. It is just the formal way that the government tells the defendant what crime he is accused of committing. It does not even raise any suspicion of guilt. Instead, the defendant starts the trial with a clean slate, with no evidence at all against him, and the law presumes he is innocent. The presumption of innocence stays with him until the government presents evidence here in court that overcomes the presumption and convinces you beyond a reasonable doubt that he is guilty. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. You must find the defendant not guilty unless the government convinces you beyond a reasonable doubt that he is guilty. The government must prove every element of the crime beyond a reasonable doubt. Proof beyond a reasonable doubt does not mean proof beyond all doubts. A reasonable doubt is a doubt based on reason and common sense. It may arise from the evidence, the lack of evidence, or the nature of the evidence. Proof beyond a reasonable doubt means proof which is so convincing that you would not hesitate to rely and act on it in making the most important decisions in your own lives. If you are convinced that the government has proved the defendant guilty beyond a reasonable doubt, say so by returning a guilty verdict. If you are not convinced, say so by returning a not guilty verdict. The defendant, Samuel Williams, is charged with armed robbery. Before you can find the defendant guilty of armed robbery, the state must prove the following four elements beyond a reasonable doubt. 1. Samuel Williams took the money or property described in the charge from the person or custody of the embassy suites using a weapon. 2. Force, violence, or assault, or putting in fear was used in the course of the taking. 3. The property taken was of some value. 4. The taking was with the intent to temporarily or permanently deprive the embassy suites of the right to the property or any benefit from it. You, as jurors, are the sole and exclusive judges of the credibility of each of the witnesses called to testify in this case, and only you determine the importance or the weight that their testimony deserves. After making your assessment concerning the credibility of a witness, you may decide to believe all of that witness testimony, only a portion of it, or none of it. In making your assessment of that witness, you should carefully scrutinize all of the testimony given by that witness, the circumstances under which each witness has testified, and all of the other evidence which tends to show whether a witness, in your opinion, is worthy of belief. Consider the witness's ability to observe you as having an accurate memory or recollection of these matters. Consider also any relation a witness may bear to either side of the case, the manner in which each side might be affected by your verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. After making your own judgment or assessment concerning the believability of a witness, you can then attach such importance or weight to that testimony, if any, that you feel it deserves. You will then be in a position to decide whether the government has proven the charge beyond a reasonable doubt. You may now retire to the deliberation room.